The way I like to describe it is if you took a heat map, dollars spent, time pressure, risk, opportunity, all those different things around contracts, if you did a heat map around, what's the risk, what's the dollar, what dollars are being spent, etc., that heat map just has this massive concentration. It's all around the dollars spent to actually negotiate the agreement and the time pressures, the risks attendant to it. And it was a great opportunity to really, really do something that could potentially change the game in terms of, can we help two parties get to an agreement much faster?
Today on LawNext, almost exactly 1 year ago, a new company, the Contract Network, came out of stealth with a mission to, quote, radically accelerate the time for contract negotiations. Its founder and CEO, Jim Wagner, is a legal tech veteran with a track record of starting and leading successful companies in the contracting and e-discovery worlds, including having co-founded the e-discovery company DiscoverReady, having been president of the contract management and analytics company Seal Software, and after Seal was acquired by DocuSign, having been vice president of Agreement Cloud strategy there. With the Contract Network, Wagner aims to solve the problem of contract negotiations taking too long and lacking tools for real-time collaboration, communication, and transparency among all parties. Wagner is my guest today to talk about what he sees as broken with the traditional contract negotiation process and how the Contract Network offers a better option. Given his 30-year career in this industry, couldn't let him go without also getting his thoughts on how it has evolved and where we are today. This is Bob Ambrogi, and you're listening to LawNext, the podcast that features the innovators and entrepreneurs who are driving what's next in law. Before we get to that conversation, let's take this moment to learn about the sponsors whose generosity supports this podcast. Stop juggling multiple legal software products and paying multiple subscriptions to manage your firm. From time tracking and automated billing to native payment processing, Bill for Time is the all-in-one solution you need. Reduce non-billable hours, enhance invoicing efficiency, and get paid up to 70% faster. Ditch additional third-party subscriptions by visiting billfortime.com. That is time.com. Check it out today. Hey listeners, before we get to today's episode, I have a favor to ask. If you enjoy LawNext, please take a moment to leave us a review on Apple Podcasts or wherever you listen to the show. Your reviews help others hear about us. We'd appreciate it. Now on to today's conversation. Jim Wagner, so happy to have you on LawNext.
I'm delighted to be here.
I really only first met you about a year ago, not that long ago, before just around the time you actually brought the Contract Network out of stealth. I know you'd been developing it for a period of time before that, but as we speak today, we're just about up to a year since you made the public announcement of this company. And obviously a lot I want to talk about with regard to that and the work that you're doing. But before we get to any of that, I think it's kind of fair to say that your entire career has been focused on contracts and documents, starting from the time you were an M&A lawyer way back when, and then through a series of companies, both that you founded and led as an executive. So I wonder, because I think it's relevant to what you're doing today, if you kind of walk through a little bit your career and how you got from there to here.
Great question, and I won't bore folks with it too long. I graduated from law school in the early 90s, and I was an M&A, private equity, commercial lawyer, and I practiced sort of big law, traditional big law background throughout the 90s, and I actually really enjoyed the practice of law. I was not one of those folks who said, this is not for me, anything like that. But I also always... I did leave, but I didn't really go far, did I? I mean, right. I've been doing things with the legal community, my entire career, to your point. But on a parallel path, there were two other things that kind of stood out. One was I did see in closing rooms over and over again, partners that I worked with who said, in the next life, I'm coming back as a client. And I'm like, you're 60 years old. You're incredibly successful by every account. And yet you're still sitting at this table saying, in the next life, I want to come back as a client. And I heard that come up over and over again. I was like, maybe there's something to that. And then the other thing that stood out to me was as I was learning my way around, was just how many things that were taking place in the practice of law that if you looked at with a critical eye, you would say, why do we do it this way? Like, there's a better way, right? And by the way, now there's such an incredible community of people who all take up that mantra, who are building businesses, building technology, who are saying there's got to be a better way. But that's what struck me, Bob, in my career.
And it wasn't as common back then for somebody to step away from law practice to embark on a career as an entrepreneur or whatever else.
Well, there was no safety net for us. Yeah. Like, where do we go? There weren't that many law technology companies. I mean, you had Westlaw and Lexis, but there weren't a lot of law technology companies, little companies like Summation and Concordance that were really driven by founders, not really scaled businesses. There was no venture money for us. So it wasn't easy. And I put down a couple of business plans in the 90s around different ideas around outsourcing technology and things like that to law firms. But at the end of the day, what made it easy for me, Bob, was that the company that's now Epic, it was DTI at the time, the founders came to me because they knew a little bit about my background, and I also led the technology initiatives for my law firm. They said, hey, why don't you come over here? We want to become a technology company. We're kind of a photocopy company now, but we want to become a technology company. And can you come over here and build that for us and be our chief operating officer? And that was sort of the transition where I never looked back. I gave up my license to practice because I didn't want to be perceived as the company's lawyer. I wanted to be a principal. And so I became chief operating officer of what's now Epic. That business, we grew tremendously. We grew over 5 times in size, and most of it organic, and most of it attributable to the introduction of the technology services, litigation support, scanning and coding, electronic discovery, hosting, those things. And then I saw an opportunity where we were delivering services, Bob, to law firms, like really, really great law firms, very talented people. And we were sort of in between corporations and law firms where we were making these deliveries because the law firms were really the ones who would consume the data, manage the data. They would manage the discovery process. And I saw this gap and said, you know what? Most law firms are actually not well equipped today. They don't have significant investments in technology. They don't have significant investment in project management. The business model itself doesn't necessarily lend itself well. And so I founded a company along with my business partner, Steve Harbor, called Discover Ready. And we went out to the market and said, you know what? You've been sending your documents to Big Law A, B, or C for them to review for discovery purposes, for investigation purposes. And we think that you're paying roughly 15 to 20 times more than you ought to be paying because there's not a lot of technology. You're paying premium rates for associates who really aren't even working on the matters. And we'll do this for you. And just to show you like where we were, this was in 2005. We were like, we'll review every email you got for $1 a document. And we went out and we told that story and people thought we were crazy and we banged our heads against walls. And really to make ends meet, I did consulting. I had a handful of people around me who we did consulting, but we would always do so in a way that was designed to, develop a deeper relationship and hopefully create an opportunity to ultimately deliver a managed service, which now the default, as you know, is managed document review for everyone. So it's really us. And then Bob Rowe was doing it. And before he sold his company to Huron. So Bob Rowe and us, we were out there telling the story. Bob was doing it for Next and Pruitt in South Carolina. We were doing it in New York City. And we were telling the story. Bob sold this company to Huron. Huron put a lot of energy behind it. All of a sudden, they were out pitching to everyone. And it's like, well, they need at least one competitor to include in the RFP. Maybe we'll get our fair share of work. And sure enough, we did. So we grew a pretty good sized company at Discover Ready. And I served as CEO there. And then Steve and I formed another little company called Apogee. And we said, we're going to take everything that we learned about doing document review and discover and using predictive coding and all those things. We had done a lot on that front. And we said, let's do the same things and let's do that in the contract world. And we did that in 2015. And we grew a little business to about 30 professionals. And we adopted a software called Seal Software. There were really two big players. There were three. There was eBrevia, NetGannon. There was Noah and Kira, and then there was Seal Software.
Yeah,
and
document analysis, review, that kind of thing.
Yeah. And Noah and Ed and Ned, who I remained close with. I mean, they're such great guys. They were a little bit more focused on the law firms, and Steve and I were all about going direct to corporate. And so Seal just made a lot of sense. And so we became ingrained in the Seal network. And anytime Seal had a project, we became sort of their go-to partner for delivering it. And ultimately, in 2018, we merged our company into Seal. And then in 2019, I became president of Seal. And then we sold the company to DocuSign in May of 2020.
Was it 182 million, something like that? Is that right?
Yeah. Well, yeah, it's a trick number.
Yeah.
They already own 15 million of it. So press release says 185, but DocuSign already owned 15 million. So they took their 15 million back so they can say it was 185 instead of 200.
Okay.
Forgive me, Dan and Scott. I gave a dirty little secret, but there you have it. But yeah, so we sold that company to DocuSign. And that was a who's who of clients, by the way, big banks, big telecom, big pharma, but Seal and tremendous credit to the team of founders who started that business and the team that really, made it come to life. But that had an incredible who's who of clients, just everyone you can possibly imagine. I mean, folks who appeared at our conference and spoke on our behalf. So it's not a secret, like Google and Meta both used our AI. I mean, that was pretty cool to know that companies like that used our AI. And then I served as vice president of Agreement Cloud Strategy at DocuSign for about 18 months before, we come to the present.
So we come to the present, and based on that career, that history that you had, I guess it's fair to say that you decided that there was a problem with how contracts are being negotiated because you started a company to address that problem. So, I mean, what was the problem you saw that you set out to address?
Yeah, it's a great question. I would start with the way I like to describe it is if you took a heat map, dollars spent, time pressure, risk, opportunity, all those different things around contracts. If you did a heat map around, what's the risk, what's the dollar, what dollars are being spent, et cetera, year 3, year 5, whatever, that heat map just has this massive concentration. It's all around the dollars spent to actually negotiate the agreements, right? And the time pressures, the risks attendant to it. And it was, the great opportunity to really, really do something that could potentially change the game in terms of, can we help two parties get to an agreement much faster? That was the idea behind the business.
Yeah. What were the speed bumps? What were the obstacles to parties getting to agreements quickly? I mean, what was it that kind of bogged down the process of negotiation?
Yeah, I think the dirty secret is that it's much simpler than people let on, and that it's the big thing is third party paper. It's third party paper. You are inflicting a contract on me that I don't know. I have to go through and read it, and I have to analyze it for risk, compliance, business terms, the whole deal, and that hurts. That hurts. and it slows everything down. There are lots of other things in terms of unsophisticated parties, over sophisticated parties, people presuming they have too much leverage, people not recognizing what market is. There are a lot of different things. And obviously, I'm sure we're going to talk a little bit about some of that particularly around the impact of market awareness. But at the end of the day, contracts slow down because we haggle over a lot of things that we all agree on or are not going to be that challenging. But in order to get to the 5 things that we really do disagree about, we take too long to get there, right? Shouldn't take 5 drafts to get to the 5 things that matter in a contract.
Yeah, I remember when I first talked to you a year ago. Well, I remember because I just reviewed my blog post that I wrote about it. But one of the things you talked about then, and I know you talked about it on your website since then, is this idea of the red line rut. What's the red line rut, and how's that a problem?
Well, the red line rut is we're just going to go back and forth and send each other red lines in a way that candidly the business community doesn't appreciate, it doesn't value. And I think we should, as professionals, all look carefully at how much value we're delivering in the context of red lines. I had a scenario. I'll give you an example. I was exchanging an agreement with someone. The lawyer came back with comments that imposed additional duties on his party. And I went back to him and I said, do you really want to do this? Because this, he'd imposed a duty for his party to return data. And he just inserted the clause. And I'm like, under an NDA. And I'm like, do you really want to create an obligation on the part of your party that they have to send me things back in an era where no one sends something back? And the reason I give it as an example, Bob, is just because it's very, very common. We pick up our pen and away we go, right? And part of it is necessitated by the fact that, again, I'm looking at something unfamiliar. If I go through and something doesn't resonate with me, there is a tendency to pick up that pen. So there are a lot of reasons why contracting is inefficient. And also there are now, the other elephant in the room is, since you and I spoke and every Joe, startup, can have generative AI at their disposal. The ability to use generative AI to help in the negotiation process is rapidly becoming ubiquitous. Really, really happening very quickly, whether you just use Microsoft Copilot, whether you do business with my buddy Dan Houck at NetDocs, everyone will have generative AI. And, for us, one of the challenges is cutting through the story to say, well, why is it that what you're doing will be more helpful to me in terms of using generative AI to negotiate agreement than Copilot or RV or NetDocuments or anything else?
Yeah. What's the answer to that?
Oh, it's a great question. I think, you're asking lots of good stuff. Yeah, we confront this on a regular basis. Part of what the value that we deliver is that we invest a lot in data models, and we invest a lot in providing clients the ability to do things much more. If you watch the demos out there and you've seen them and you've actually, you've engaged with these folks, they'll do a demo that says, hey, make the agreement mutual instead of unilateral. And they'll show that. And it's kind of a card trick where they'll say, our payment terms are 45 days. So when you see the agreement, fix it or whatever. What we've seen is that there's not, relative to the sophistication that people who do this every day need in terms of really understanding the nuances of what they're looking at and what they need changed, that level of execution, we have not seen many folks who have really dialed in what they're doing to the point where they know each and every nuance of how to negotiate a particular contract. Instead, they kind of have these general tools that they're bringing forward, and they're valuable, and I applaud it. It's great. But when we turn a document into data, for example, let's say that we're analyzing a clinical trial agreement. When we analyze a clinical trial agreement for a large, pharma or for a large healthcare concern, one of the things that's most important to them is they want the same analysis every single time. So they don't want subject injury, patient subject injury to show up as patient subject injury one time, and then another one the next time for it to show up as patient injury, and then the next time for it to show up as, subject damage or whatever. They need it to come out exactly the same way every time. Most of the applications that are being built aren't really being built with an eye toward, wait a minute, I want to be able to run the same KPIs. I want to run the same dashboards. I want to be able to surface the same insights according to the same data model every time. And we've taken that approach. You saw our platform from the word go. It's very structured. We turn documents into data, very, very repeatable. When you turn documents into data in the same way, it really opens up the possibilities in terms of how granular you can be as to each subject, as to what is preferred, permitted, not permitted, etc. So what that allows us to do is have our clients deploy very, very intricate playbooks that then lead to downstream better negotiations. Those would sort of be the two big ones: is really great data model and allowing for a more sophisticated approach rather than just sort of a thin implementation. The third thing that I also hope we're going to get a chance to talk about today is the opportunity to surface market insights. And I think we're pretty unique in that regard. There have been some folks who have platforms that are dedicated sort of exclusively to market insights. Most of those have been about public documents rather than negotiated agreements. And what we're doing is we're surfacing market insights to all participants for certain use cases where we can tell them, listen, you're issuing a document you're an investment bank, you're issuing a document to a private equity fund, you're saying that the private equity fund will cause its representatives to do X, Y, and Z. And down to the word, Bob, we can say, it's not cause, what's market is you will direct or advise your representatives. And if you go to market with the word cause, you're out of market, it's going to get marked up 80% of the time, and so on. And so those market insights can become very valuable, hopefully, not only in the midst of negotiations, but actually helping the party who's originating the agreement to make their agreement better before they send it. And that is probably where we have the most traction in the market, is our ability to tell folks in advance, this is what's going to happen with your negotiations. Do you want to do something about it?
And how are you providing those market insights? Where are you getting that data, and are you effectively benchmarking agreements against that data? Or?
So last question first. Yes, we do benchmark the agreements. So if you give us an agreement, we can benchmark it against your standards. So you can have a playbook and we can benchmark it against that. Or we can also benchmark it against market. Your standards and market may not be the same, but we'll give you both benchmarks. The second is how do we get it? There are really two pieces to how we get it. One is, let's talk first about how we source the data. We source the data only from parties who are specifically opting in and participating in our market data studies because they want to have access to it, right? They want to participate. And then the data is aggregated, anonymized. There's no way that you read our study and said, oh, I know exactly where that came from. We just don't do that. And it will be possible to do that. But we get the data from sources who are negotiating relevant agreements in the community, who are contributing those documents, and they're being anonymized and aggregated. The next piece of it, which is kind of fun, but probably a little bit too, maybe a session for another day, is how do we use generative AI, right? And this is the thing that I'm, in many respects, most excited about when people say, well, how do you distinguish yourself between something that's a drafting tool, this, that, the other? From a generative AI perspective, what we say is, just like we're super ambitious about it. I put it on LinkedIn, like, what happens when one company and its partners want to eliminate 80% of the negotiation for an entire industry. And that's what we aspire to. Now, obviously, time will tell whether we're able to accomplish that and how many use cases, but we're digging deep in the clinical trials community. We're digging deep in the investment banking and private markets community. And we've already shown, we've already demonstrated that we will be able to have a massive impact on negotiations if folks sort of, play the game with us.
Shortly before Jim Wagner and I spoke, his company, the Contract Network, in partnership with the global law firm Eversheds Sutherland and the global managed services company Integrion, partnered on a study of NDA negotiations in M&A matters, analyzing over 20,000 anonymized negotiation points to better understand the power dynamics in those negotiations. What did they find? Well, stay tuned, because in a moment I'll ask Jim about that study and what it revealed. But first, please take a moment to learn about the sponsors who so generously support this podcast. Looking for a solution to centralize your practice? Look no further than Bill for Time, a legal practice management software that helps you easily track time, automate billing, share documents, and so much more, all within one platform. Modernize your internal processes with Bill for Time and focus on what matters the most. Visit billfortime.com today to learn more. That's Bill, the number 4, time.com. Welcome back to LawNext. I'm speaking with Jim Wagner, the co-founder of the Contract Network, a year-old startup that has developed a platform to, quote, radically accelerate contract negotiations. In the second part of our discussion, we'll hear about a study the company just completed looking at the power dynamics in NDA negotiations. We'll also talk about the company's work with the Mayo Clinic to streamline clinical trial agreements, and hear Jim's thoughts on the state of the contracts market and the impact of AI. Let's get back to the conversation. I know that you just finished or just recently completed a study, I guess, that you did on analyzing NDA negotiations and M&A matters, which, fair to say, it validates, or at least you find that it validates that kind of market-based approach that you were just talking about. Can you kind of describe that and what you found?
Yeah, sure. So we worked with Eversheds Sutherland. We worked with the Sutherland part of the equation here in Atlanta. We worked with Integrion, and then we worked with a number of folks in the investment banking community who work sort of quietly behind the scenes. And we analyzed over 20,000 M&A NDA negotiation points. And we use generative AI to do so, and use some really, really fun techniques to get there. I think, we're sort of reflecting a little bit of the experience that we have in this arena to be able to actually pull something like that off. From that, if we sort of take step by step, first we had to go in and create a data model. Because as one person will say it's injunctive relief, the next person will say it's remedies, the next person, we have to cut through the noise, and we have to identify basically every subject that's addressed in these agreements. So we developed a data model. Then we use what's called a RAG implementation, and it's a very common form of implementation, for folks who are playing, at a big scale. And that is basically using a sophisticated AI pipeline. You create, in essence, a fingerprint for every sentence that comes in. That's called an embedding. And you marry together each sentence that basically closely matches one another. So we put all the injunctive relief clauses together, all of the return or destroy clauses, all of the, publicity clauses, whatever they are, right? So we use those techniques to group together all of the sentences in these NDAs that sort of belong together, no matter how they were structured. That was the first piece of it. Where things got exciting with the generative AI was then to analyze the original version of the template, the revised version of the template, and the final version of the template to really understand the intricacies of the negotiations. I'm going to pause for 1 second because there's a myth that NDAs don't get negotiated or shouldn't get negotiated. And by the way, I think 90% of all NDAs should not get negotiated. We use, common terms, common paper, Jake Stein, we use bond terms, Todd, we've used one NDA, Electra, some. So I'm a big believer in the NDA standardization world. In the M&A community, the NDAs really get negotiated and the issues are way, way more intricate than what any of those NDAs are designed to accomplish.
So the standardization movement in NDAs isn't really relevant to the M&A world, is what you're saying.
It could be. And by the way, I'm fully supportive of that as well. It could be. Just recognize that there have been efforts on that front and they have not taken hold, and there are a lot of different moving pieces in the market. It could be, and we're all in for it. And I think, hopefully actually can play a role in driving toward market standards and actually making it clear you should be taking a more formulaic approach. But there is a myth that NDAs don't get negotiated and they don't matter. Say what you will, on an M&A NDA, you are signing a non-solicit clause, period. You're signing up not to hire someone else's employees. That becomes slightly more real. You're signing up to say you won't go out and conduct due diligence in a way that even if you don't use the counterparty's information, might make it clear to the entire market that actually you're about to buy that company. There are things called standstills. There are lockups on lenders. I mean, there's a bunch of moving pieces. So NDAs in the M&A context are not the same as the rest of the NDAs. Let's just make that clear. And I could show you markup after markup around that.
But doesn't your study kind of counter that in the sense that your study concludes that in fact there is a large amount of consistency among the NDAs once they're finalized and agreed on?
That's exactly right. So what I would suggest to you is that 80% of the issues that are encountered in NDA negotiations don't have to really be issues. They can be solved in advance, and that it's that last 20% that says, do you have a lockup on lenders? Do you have a standstill? Do you, who are the covered persons for non-solicits? Those things get negotiated. And that was really my point, was actually there are real issues that get negotiated. The flip side of that is that, again, 80% of the document does not have to be negotiated. I'm just, and I can give you example after example. Investment banks will send out agreements that say that the private equity firm will certify in writing that they destroy the information. And not only will they certify, but they'll have an authorized officer of and every time counsel for the private equity firm is going to say, I will confirm to you, I won't certify to you, I will not have an authorized officer of the company do that. And you're going to take an email as being sufficient recognition of the fact that we've done this, right? They're going to make that markup, and every investment bank is going to accept that change whole cloth. They are not going to push back on that whatsoever. And so it's like, well, wait a minute. If the buyer is going to make this comment and you, this seller, are going to accept this comment, what is the logical behavior that you should engage in? Let's fix it before you send it. And there's about 80% of every markup in the M&A NDA community that does not need to be marked because it's not controversial. Let's just fix it up front. Then you can haggle over governing law. What's the term of the NDA? Who's the covered persons for non-solicits? Is there some type of lockup for lenders? And are your representatives and affiliates covered by these different clauses? Those are the real issues. I rattled them off really quickly, but if we had people who were really, really experts in the area, they would say, yep, you got that right.
So the lesson then, in part, is that one way to accelerate the negotiation process is to not spend a whole lot of time on the stuff that is pretty much market standard and focus on the stuff that's really meaty to the deal at hand.
And the problem is two things. One is that what's the transparency as to what's market standard? And the answer is nil. There's, it's all word of mouth as to what's standard. You go to your lawyer, and that's why, you pay Kirkland and Ellis over $1,000 an hour, because they're going to tell you what's market, and kudos to them. But there are certain areas where some of the data is so common, should be available. Let's just make it available to everyone who's negotiating. But the other piece of it is that when you say, let's not waste too much time on it, I'm an advocate of not wasting too much time on it. But that does mean that drafters have to fix the agreements before they go out. Like, they just have to acknowledge the other party has a legitimate concern. They'll send out an agreement that says, you cannot contact the target company except directly through the investment bank. And this might be one of your suppliers, or might be one of your core customers, or one of your core business partners. They make the buyers make the comment every time, except otherwise in the ordinary course of business, not related to the transaction, you won't contact them. Lean in, fellas. The water's fine. Just fix your forms.
Yeah. When you guys, blanking on the name of your co-founder, I'm sorry, Bill Murphy, who is a former chief technology officer at Blackstone, and when you started this company, well, you started the company more than a year ago, but when you launched the company last year, again, one of the real kind of missions that you were focused on was this idea of accelerating contract negotiations, and you started initially with this partnership with Mayo Clinic. Focused on clinical trial agreements. Why that focus? Why that partnership? How did that make sense for what you're doing?
Yep. And by the way, I just got back. I just spent 3.5 days with the team from Mayo Clinic at a large conference about negotiating clinical trial agreements. It was fantastic. We're really, really excited. Just piggybacking off of what we did earlier, we talked about the market study on M&A NDA. We're doing it in the clinical trial context now. So we're literally kicking off that study. We were in New Orleans, and we got a bunch of folks in a room who said, actually, we really like what you're doing, and we want to participate. Global, pharma, lots of folks, household names in terms of hospitals and state academic medical centers. Is really, really exciting. We haven't walked away from the clinical trial use case at all. As a matter of fact, we're really excited about the impact that we can have, and how many folks appear, they haven't sent us their agreements yet. We got one batch this morning. It's amazing. We already got a batch of agreements from an absolute top tier, wow, thank you. That happened fast. So, in terms of tackling clinical trials, those agreements are ubiquitous. And if you think about what happened in the rush to discover cure, preventative medicine, et cetera, it really showed, if we think about, the elasticity of our supply chain, one of the things that really, really came out was how inelastic we were in terms of starting and executing clinical trials. The average clinical trial takes well over 3 months to initiate, or the average clinical trial agreement takes over 3 months to negotiate. And it's the same players, it's the same parties doing this thing over and over and over again. And, we have the belief that as the community as a whole understands more about what's market, and also if the community as a whole can be given tools like generative AI, collaboration tools, et cetera, that we can help them get to agreements much, much faster. And we're really excited to properly kick off that business later this summer.
And where else are you expanding into? Are you doing more M&A at this point? You're still, what's actually the status of the company at this point? Because you're still, I think it still says sign up for early access on your website.
Yeah.
So where are you right now, and what are you doing right now?
Yeah. So we do have clients who are using the platform, negotiating every day. I love it when I get a total that says how many agreements got negotiated, how many signatures, but it's a small number. It's still a small number. We're still doing a lot in terms of making the platform right. The biggest challenge that we have, being completely transparent, is if we're lucky enough that Mayo Clinic issues an agreement to a counterparty on our platform, that's great. But what's the counterparty's going to experience going to be? And they're going to say, who are these people? Why should we trust an agreement that arrived here? Even if they promise us data and market insights, like that's a neat trick, but can we really do this? So we're just getting started in that regard, but we do have people using the platform every day, and our core use cases haven't changed. We're really focused on private markets, M&A, NDA, and extending from there into some related agreements, and then on the clinical trial use case. Clinical trials, by the way, is clinical trial agreement, NDA related to that, a materials transfer agreement, and a data use agreement, and sometimes people will negotiate their informed consents. So it's actually a lot of different agreement types that have to be negotiated on the platform. Where we go from here, part of it is putting the product in sort of out there where people can build their own use cases that they don't require us to participate. And I think we're making really good strides on that. We do have other areas that we see as being, potentially very, very valuable. So we've got a fairly robust roadmap in terms of other use cases that have built-in networks, built-in communities that everyone is stuck in a rut. So I'll give you an example, and I'm not saying that this is a priority use case for us, but think about construction companies. Construction companies deal with, they set up projects, they deal with the same subcontractors, they deal with the same issues over and over and over again. There are actually a lot of communities that are like that, that are possibilities for us as to where we go. But none of them are a priority, candidly, relative to delivering the value that we need to deliver with respect to the clinical trial community and with respect to the M&A community.
Yeah, we haven't explicitly talked about this so far in this interview, but what is it exactly that your platform does?
Yeah. So first of all, one place, all parties come together, right? And so, Bob, if you had a Word file, you said, hey, Jim, before you appear on my podcast, I've got we have a license agreement. We need to send it over. You could take that Word file, you could upload it. We would immediately read it. We would abstract the agreement for you. So before you even send it, we would read it. We would abstract it for you. We would align it to a data model for you. And by the way, that would all take place in less than 5 minutes. You've uploaded your work file. You could say, I want to send this to my counterparty. Type in Jim Wagner at the Contract Network, hit send, and away it goes. When I receive the agreement, when I receive the agreement from you, and I say, who the heck is this? We try to give a warm welcome, but we also give an abstract of the agreement. So even though you haven't paid a penny, you don't know who we are, the first thing that you get, the first link is see an AI abstract of the agreement. We've gotten really good feedback on that. People like having that, especially it's, if they've never experienced AI before, or they're like, this is really nice that someone is being thoughtful and helping us see what's in the agreement before we ever receive it. The second thing is that if the counterparty has negotiated on our platform before for the same type of agreement, we will have saved for them what they did the last time, and we'll say, do you want to apply the same principles that you used in your last negotiation to compare to this agreement? And so it will immediately compare the agreement that they just received to their principles. We call them profiles, and those profiles can either be explicit language that they've accepted in the past, or maybe just some guidance. We prefer 30 days, but we'll take 45 days, to use that simple example that I described earlier. So we immediately allow a recipient to compare the agreement to their standards. When they go in, and by the way, we also allow them to collaborate. So if you think about some of the beauty, and I'm sure you use Google Docs or Word or both, if you think about the beauty of collaborating with others, in contracts, people are pretty limited in terms of what they want to do. As a matter of fact, usually there's a metadata scrubber that says, whatever you do, don't include a comment, the counterparty, etc. So what we do is we have channels, we have communication channels. And so I can comment to my counterparty and everyone can see, but I also have a private collaboration channel, all in the same document that says, privately, I want to communicate with Kyle Counsel. I want to communicate with Fred Finance. I want to communicate with whomever. I can go in and I can do that. Once I've revised the agreement and sent it back to you, Bob, when you got it, when you receive the agreement, you're going to have another really positive moment. And that is that without even opening the red line, the first thing that you'll get a summary of everything I changed in plain language, written, not in a technical way that, we literally write it up two ways. We write it up one way for the lawyer in you, if you're like, I want to see all the details, and we write it up in the other way, which is what does a business principal want to see, what they want to know, and we write it up in plain language. So you'll get your red line. You'll see in plain language what changed. You'll have the ability to go in, accept or reject. You also can have profiles for your negotiations. It says on round 2 we accept this, on round 3 we accept that, etc. If you want to use negotiation strategies that are multi-round, you have the ability to say, I know we get this comment a lot. Yes, we will, we'll make this aligned with our profile, or we get this comment a lot. We do not do this. Make sure it shows up as, we have a little color dashboard that says this does not align with your standards, or it does align with your standards. So a lot of collaboration features, great summaries, plain language, and then very importantly, compare the agreement to my standards. We'll also be doing the redlining itself, entering in the red lines this summer as well. We've been working on that for a while.
There is a fairly extensive contracts tech landscape out there right now of various different kinds of products, from initial drafting and negotiation tools through review tools, through contract lifecycle management software. Where do you fit in on that landscape?
Yeah, we are a collaboration platform, which I think puts us in a little bit of a unique position. I think the applications that you're seeing that are coming at the market fast and furious are compare to my standards and suggest revisions, or create some type of summary. We're a collaboration platform, which is actually pretty different. Build my team, build a distribution list where I know it goes to exactly who it's supposed to go to on my direct recipients. I know it's supposed to go to my BCCs. I have the ability to collaborate with my internal team on an ad hoc basis. So we really are a collaboration platform that's a little bit unique, which maybe will create a new category, or maybe it'll turn out folks say, this is a category that never should have existed. What were these guys thinking?
It sounds like a new category. I can't think of anybody who's really doing exactly what you're doing. There's adjacent products out there, but not directly what you're doing.
I think Jake Stein and Todd, Common Paper and Bond Terms, they have two-sided platforms, but they are completely contingent on your using their forms, and they're building a great experience with those applications. They're really impressive. So they definitely buy in. They're kind of doing a best of both worlds, where they're saying the agreements ought to be standardized and we ought to have one place to come to get the deals done. And so they're building around that. I think the other ones, a lot of where we probably fit in, I think, Bob, is almost like an extension of the deal rooms, that are out there, the Merrill data sites and Intralinks of the world, really becoming sort of a next generation of, how does everyone come together to get a deal done? And we're excited about it. We think we can carve out a space for sure.
Yeah, that's what it sounds to me like that. It sounded to me like the most analogous to something like a deal room like that. I'd be curious kind of on your thoughts on how your perspective on where we are right now in this market with the benefit of that hindsight. I know you're, a big adopter and really interested in generative AI and how it's going to impact this market. I mean, what are your kind of thoughts generally about where we are and what's going on in the market right now?
One of the things that's most interesting is that, legal gets a reputation as being laggards for lots of good reasons. Legal is actually leading with respect to technology and AI, and that's pretty fun.
Do you think that's something new, or has it always been that way?
Well, let's be really clear. And there are certain aspects of legal that where legal has been leading for years. And I kind of have my history of legal technology that's waiting in the can, Bob. Someday you and I will go through and we'll talk about the big moments, the seminal moments. And one of those was around the discovery of the tobacco, the catalog of tobacco documents, and big tobacco, and the plaintiffs' firms all recognizing that the better way to manage, literally truckloads and 50 years of documents, was to scan those documents. Steve Harvard, my business partner since 2004, he actually built one of the very first imaging businesses, giant platters and so much horsepower that you had to have to scan the documents and to turn them into searchable text. So in that regard, legal has actually led on search and retrieval for a long time. They've really been heavy users in search and retrieval. Outside of that, not so much.
Yeah. No, I agree with that assessment. And obviously the e-discovery area was one area where there was some pioneering stuff done in the area of application of AI to legal practice.
Yeah. I mean, I really look at it. The tobacco litigation was massive. Bill Gates' Microsoft email was where he said, crush them all, or whatever he said, that really, became very clear that email was really where the action was.
We're forever indebted to Enron, right?
Well, we're indebted to Enron we're indebted to Enron because it gave every tech vendor a demo set. So we're all indebted in that way. Enron followed closely on the heels of the Microsoft antitrust. So those two kind of go hand in hand. I think Enron, this is it's my absolute inside baseball. What does this guy know? I tend to think of Microsoft as actually being sort of seminal to where folks said, wait a minute, I need to get at the executive's email. And Enron proved that for sure.
Jim, I could talk to you all day, but we don't have all day to talk, at least not for this recording. But I'd like to ask you if there's anything else you wanted to point out about what you're doing, about the contract network that we haven't talked about so far.
Gosh, I think the biggest thing that I would talk about is community. And in that regard, I've given you kudos there. And I think what you've done. I think Richard Tromans, has really served as a contributor to the community. I think of what Zach and the Legal Tech Fund have done in terms of the community.
And they're an investor in. We didn't even talk about your investment, but they're an investor in your company.
They are an investor in my company, and so it's but really, in answer to the question about is there anything else that I want to say about my company? We're at a really, really great time in the legal community. There are voices, there are audiences, there are thoughtful contributors, and it's very, very exciting. I think for our initiative, for our company, we need people who want to be a part of a community, who say, actually, we really like the notion, we like the idea of what they're doing, and so we're happy to be a part of that community. But I think the bigger message is just how exciting it is to be part of this community as a whole, and to also celebrate and thank the people who are really doing a lot to make that happen. And so it's just I appreciate everything that you guys do.
Well, thank you. Well, I appreciate what you do. I think it's really interesting what you're doing, and I hope it catches fire and changes the world of negotiations.
Send me your next agreement. Come on, I know you negotiate them every day.
I forgot to have you sign my highly complex agreement before you came on this podcast. I mentioned my wife is a contracts lawyer. If she had her way, I probably would have an agreement for every podcast person, but not today.
Well, thank you so much. I really appreciate your spending time with me, and it really has been great getting to spend time with you over the last year.
Yeah, well, thanks as well, and appreciate it. Appreciate your time. My sincere thanks to Jim Wagner, co-founder and CEO of the Contract Network, for joining me today. I enjoyed the conversation. I hope you did too. If you'd like to share your thoughts or comments on today's show, please do so by messaging us on LinkedIn or X, or by emailing me directly, ambrogi@gmail.com. If you're a fan of LawNext, please leave us a review wherever you get your podcasts. LawNext is a production of LawNext Media. I'm your host, Bob Ambrogi. I hope you'll join us again next time for another episode of LawNext.